Hello, welcome to today's immigration tidbit. It is very unlikely that your uncle is going to avoid being placed into deportation. Now, just to confirm here the procedures, they're not just deported, okay? He doesn't just finish his sentence and then, they stick him on a bus to Mexico. It doesn't work like that. The government has to put him in removal proceedings, and then they have to prove his removability. He has to prove he doesn't have any defenses. And assuming that all is lost, then he will be deported. So when he finishes his sentence, immigration will put a hold on him. ICE will put a hold on him just being released. And then they have a certain very small amount of time to get him. It depends also where he is. There are certain states that could care less how long he's in detention and will keep him there until the end of time, until ICE gets him, regardless of the rules. And then there are states that follow the laws that if ICE is not there, then they release him. So assuming that ICE is there, what will happen is the immigration will transfer him to an immigration detention facility, upon which removal proceedings will begin. Now, just so you know, an ICE official will visit him more than once, most likely, while he is in in criminal detention. They will likely say stuff to him that will make him want to sign a voluntary deportation paper. They'll say stuff like, "You have no chance of winning. You're going to be transferred to immigration detention and you'll be there for the next 20 years fighting." And they're going to say, "If you think this is bad, immigration detention is worse. But all you need to do is sign this document and everything will be fine." But what he's doing, if he does that, is he's giving away all his rights. He's not given the opportunity to fight at all, and he will be deported. And a lot of times they sit in detention for a while they're scheduling them to be deported. So assuming he doesn't want to just head off to Mexico, he needs to not sign that voluntary deportation paper. There's nothing they can do to force him to sign it, and then fight his case. Now, you're saying that he's going to be released in May of 2025, which gives about a year, almost exactly a year, in which to try to do things to try to minimize or try to win a deportation. Now, there's no realistic way he's going to avoid being placed in deportation, so you have to change the way you look at things here. You have to try to do things that might help him win once he gets into deportation. Just take it as a given he's going to be put into deportation. So child sexual abuse normally is an aggravated felon. So in that particular case, I would need to have some facts in order to know if it was a federal court or a state court. Did he plead guilty? Was there a jury trial? What was the actual name of the conviction? If he pled guilty, was he given the full immigration consequences? Did he speak with an immigration attorney? Was he given his advisals as to pleading guilty even though he wasn't a U.S. citizen? So, depending on the answers to all of that, he might be able, as of right now, not after he's transferred to immigration detention, as of right now, there could be motions that could be made to either vacate or reduce the crime so that he wouldn't be considered an aggravated felon. I'd also need to know the facts. Maybe he took a plea deal because he didn't understand what was going on. Maybe he took a plea deal because he was protecting someone who actually did the sexual abuse, and maybe he didn't, but maybe he's just protecting that person. Whatever it is, I would need to know, okay, in order to see if there's other grounds to try to set aside or reduce the conviction. And again, I understand he's already been convicted and is serving the time, but there are ways to do it. And it also depends where he is. Now, given that, I also need to know if there's other grounds. Let's assume that he can't realistically reduce the conviction or vacate it. I need to see if there's other grounds that might be available that might allow him to remain here even though he's an aggravated felon. And such of those could be he's a material witness. I don't know, maybe this case he was a material witness, and he could be testifying and helping FBI or immigration or other federal officials. He might have been a victim of crime. Okay, that's a possibility. He might have been trafficked himself in some manner, work trafficking, where he had to work for years and never got paid type thing. So all those are different kinds of visas, U, T, and so forth, that do allow waivers of aggravated felonies. So there are possibilities. I need to know how long he's been in the U.S. and where his parents are, if his parents became citizens before he turned 18, if he's a lawful permanent resident here in the U.S., and what year he came. There may or may not be derivative citizenship issues. So as you can see, it's not a simple yes or no, okay? But it's a possibility. And now's the time to start moving on this. Don't wait until he's transferred, because immigration court will say they're not going to wait either. They're going to move forward and do what they do. So you have a whole year to try to minimize what's going to happen when he gets put into removal. Because if he's removed as an aggravated felon, the law says he's removed the rest of his life and he's not ever coming back. So now's the time to move on this. Okay?